Hello and welcome to the inaugural Field Seymour Parks Employment Law webinar. My name is Ian McRae and I head up the team here at FSP. So essentially the purpose of these webinars is to try and bring some of the content from our regular breakfast seminars to a slightly wider audience. So if you're unable to attend our events because of location, childcare, or because simply you don't want to get up for an 8 AM start, then these webinars are for you. So you'll see that we have split this webinar into 4 sections, so you can dip in and out to see the bits which are most of interest to you. What we'll do now is take you through the 4 aspects that we'll be covering today. And essentially this webinar is designed to ensure that you're aware of what we think are the 4 most key developments in employment law in 2017. Now, let's look at the items that we're going to cover off. So, firstly, we'll be looking at developments in respect of employee and worker status. So this is a very hot topic. You may already have seen a lot of this in the press recently, and we'll be looking at some of the key developments there. The second part of this webinar, you can see, is about holiday pay calculations and how we now consider that it is the crucial time for employers to take action in respect to their holiday pay calculations. The third part will talk about the incoming general data protection regulations, which are going to replace the Data Protection Act, and what you need as employers to be doing about that this year. And the fourth and final element will be dealing with the gender pay reporting, which is come in as of April 2017. So moving on, we will start to look at employee and worker status. Now, what I've done for you here is give you a few selected headlines from a lot of the press coverage that there's been on this issue lately. As you can see, it's attracted attention outside of just us solicitors. And essentially, a lot of these cases have concerned the gig economy. So for those of you who aren't familiar with that phrase or that type of business, generally that's businesses that instruct people on a freelance ad hoc basis. And these cases have concerned whether those individuals are being treated and classified correctly as self-employed. And the 3 headlines I've pulled up for you today, you will see there's the threat of a claim being brought against Deliveroo by its couriers, the recent Court of Appeal decision against Pimlico plumbers, and the one that I'm particularly going to focus on today is the Uber driver decision, which received a lot of publicity towards the end of last year. So before we get into the details of those cases, what I think it's wise for us to do is to have a little look at what are the different classes of individuals who provide services, and frankly why that matters and why you should be interested in that. So the 3 different classes I want to talk about. The first one is the one that most people will be familiar with, which is the idea of your classic employee. So they may be full-time, they may be part-time, but they're an employee of the business and they qualify for all of the employment law protections that covers. So the right not to be unfairly dismissed, the right to a statutory redundancy payment. You then have a second class which people are less familiar with, and this is the idea of a worker. Now this is a sort of halfway house between a full employee and somebody who is a self-employed contractor. So they qualify for some employment law protections, but not the full suite. So for example, they have the right to national minimum wage or the national living wage. They have the right to paid holiday. They equally will have right not to be discriminated against. And then at the other end of the scale, you have the third class, which is the sort of the genuine self-employed. So somebody who is in business on their own account. And they generally will not qualify, provided they are genuinely self-employed, for any employment law protections at all. Their relationship will just be governed by the contract between them and the end user. So you can see already that how people are classified will impact upon the legal protections they have in their position. There are also tax implications, which is outside really the scope of the webinar today, but you should at least be aware that classification will also impact upon how the payments that are made to these individuals are taxed. So are or should PAYE deductions being made at source, and are there VAT issues? So one way or another, how people are classified is very important. Now, as you've seen, there's been a raft of court and tribunal decisions on this issue, and the one that we're going to talk about today, which is a useful example, is the Uber decision. Now, for those of you who are not familiar with Uber's services, essentially their position is they are a technology company, and they use an app on smartphones to connect what they consider self-employed drivers with potential passengers. And their position is always that they are a technology company and not a taxi company. And it's that relationship which has been recently considered by the Employment Tribunal. Now, as I've said, Uber treats its drivers as self-employed. And essentially this case concerns the fact that this was challenged by some of those drivers seeking worker status. So that halfway house status, not full employee, but worker status. And in particular, they were seeking national minimum wage and paid holiday. Now, what I'm going to do now is just look at some of the key facts of the case, so you've got some of the context of the decision that the tribunal reaches. Now, essentially, the Uber drivers are not actually required to take work, but they do get penalised if they are signed in on their app as being able to accept work and then turn down jobs. And ultimately, they get issued with warnings, and they can eventually be sort of blocked or suspended from the service entirely. They supply their own vehicle, and they meet all associated costs, such as petrol and insurance. They have to follow the route that is specified by Uber, which is sent to their mobile phone, and they're guided to it by GPS, unless there's a specific request by the passenger to go a different way. Fee is determined by Uber, so it's the fee that's the fee they have to charge the end customer. And the driver then pays a percentage of their income essentially to Uber as in exchange for use of their app and their technology. Drivers can be excluded from the service if they fall below a certain sort of average rating. So there's a facility to rate each driver by the passenger, and if that falls below an acceptable level, they can get suspended entirely. And then you have the point that if there are complaints, Uber will often also deal with them itself and resolve them itself. And the evidence before the tribunal suggested that the driver often wouldn't even be involved in that process. So that's a brief sort of factual explanation of the nature of the relationship and how it worked in practice. Now, what the tribunal found is that these individuals, these drivers, were not actually self-employed, and they were in fact workers. And they found that they were workers when they had the app switched on, that they were within their authorised territory, and that they were willing and able to accept work. And what that means, and the implications of this decision, is that during those periods of time, they are workers, and as such should be receiving as a minimum, national minimum or national living wage, and also accruing paid holiday. The tribunal was frankly somewhat unimpressed by Uber's suggestion that each of these individuals was in business of their own account. And I've included on the slides there a quote from them where they said it was frankly ridiculous that Uber could be considered a mosaic of 30,000 small businesses linked by a common platform. Now, if you go and look at the judgment, you'll see that it is very lengthy, it's very long, it's very detailed. But one of the key factors in the decision that the tribunal reached in deciding these people were workers rather than self-employed was to do with the degree of control that Uber had over and exercised over the drivers. And they found that that was inconsistent with these individuals being self-employed. And that's a real risk for all companies that have self-employed contractors, because it's quite easy to get drawn into wanting to place restrictions on them to protect your brand, to ensure quality of service. But if you go too far, as the tribunal found that Uber had, then you end up unwittingly giving them employment rights. So what are the implications of this decision? Well, the first and most obvious implication is for other gig economy businesses. If they have to start accepting that the people providing services for them are not self-employed and are workers, or maybe even employees, then they'll need to be paying national minimum wage, national living wage, they'll need to be making paid holiday, and they'll also need to be ensuring that these people aren't being discriminated against and there's no other infringement of those other worker rights. And that could be costly, and so it could ultimately undermine that business model. It's also fair to say that these cases have generated a huge amount of publicity for what was essentially a tribunal decision, and is seen as a growth area by a number of the unions, where they're looking to recruit new members, looking to bring employment protections to people who would otherwise not have them. And what that means is that more and more people are aware that employment status is important, and that what it says in their contract may not be the end of the story. So there's just a greater practical risk of people bringing claims or asserting that they have employment or worker rights. So it's important to make sure that all businesses are classifying the people who provide services to them correctly. There's a few caveats to this, in that this particular Uber decision is not binding on other tribunals or courts. It was a first instance decision by an individual tribunal and is currently subject to an appeal. It's also been decided on very specific facts relating to Uber, and these cases will change from business to business, from scenario to scenario. And the fact that the drivers here were workers does not mean they'll automatically be workers in every other case. There's also been no fundamental change in the law. This is getting a lot more high profile, but ultimately the tests that the tribunal and the courts are applying are the same as they have been for years. It's a very settled area, and we'll look at what some of those tests are in a moment. And the tribunal did admit in its judgment that actually Uber's model could have been altered so that these drivers could genuinely have been self-employed. Now what they didn't do is go on to tell Uber how to alter their business model, because no doubt that's probably what they'd have then gone and done. But there certainly was an indication that you can have different business models where it is legitimate and appropriate to have self-employed people. So taking the tests that we've just looked at and the lessons we can learn from this case, how do you actually identify workers and employees? Now, the key issue in this case was whether or not these drivers were workers. And essentially, any employee will also automatically be a worker. So if they're an employee and recognised as an employee, that's to a certain extent the end of that aspect of analysis. They will qualify for all those worker protections. But the more tricky bit is it also covers people who undertake work personally, but are also not in business on their own account. So there's two elements to that. A, the need or the requirement for them to do it themselves. And secondly, this idea that they're not sort of in business on their own account. So it's not a business-to-business relationship. And there are a whole host of factors that tribunals will look at when assessing if someone is an employee, a worker, or self-employed. And as I say, each case will decide on its own facts, but what I'll do now is highlight some of the key aspects that a tribunal would look at, and indeed you may need to look at in determining the correct status of your own individuals. So the first one is this idea of mutual obligations. So in an employment status, that would mean that the employer is obliged to give work and the employee is obliged to do it. That could be contrasted with a situation where the business is not guaranteeing that any work would be provided, and equally the individual may not be guaranteeing that they're available or willing to do that work when requested. Personal service, we've seen how important that is for worker status. Obviously, for an employee, they have to do the job that they're instructed to do. It's not acceptable for them to send along their substitute, send along their neighbour because they don't feel up to it one day. They have to do it themselves. And that can be contrasted with a genuine self-employed contractor relationship, where often it's not so important who actually does the job, as long as the services are adequately provided. And a right of substitution is normal in those circumstances. Then also have these 2 points about control and integration. So control, who decides when and how the work is done. Again, for an employment relationship, that's normally quite heavily controlled. There'll normally be set hours of work, a lot of processes, policies that will need to be complied with. For the self-employed, often it will be the other end of the scale. So they will have freedom to determine how and when they do the work, provided that the services are adequately carried out. The integration point is all to do with how far integrated are the individuals into the business. The Christmas party test is the one element that can sometimes apply. Do you invite your self-employed contractors to your Christmas party? Are they treated the same as any other employee? Do they have work email addresses? Do they wear the same uniform as everybody else? All those types of things can be taken into account. Exclusivity. Does the individual have to work for you alone, either during the length of the contract or indeed afterwards? And the nature of the length of engagement can be a factor as well. Is it a project-based assignment, or is it something that's ongoing? Tribunals and courts will also look at how people are remunerated and what risk each party bears. So in an employment relationship, obviously it's normally regular, set, monthly or weekly amounts of pay. Whereas in a self-employed or business-to-business relationship, the person providing the services may take on more risk. And that may be more risk in respect of liability, in respect of the quality of the work that they've produced, or it could be risk in terms of the amount that they get paid. They may get paid more by results. And then a final one that I'll highlight is the point about equipment. Who provides the equipment for the services? For an employee, normally the employer provides everything they need to do their job. Self-employed contractors may be slightly different. They provide their own equipment. Now, I think it's important to stress that not one of these factors will be determinative in itself. So I'm not instantly suggesting you can't invite any of your self-employed contractors to your Christmas party. It's looking at the entire picture. And what you need to do as an employer is ensure that looking across these range of things, that you're correctly classifying people. So what should you be doing now? In short, you should be reviewing and auditing those relationships of your employees, your workers, and your self-employed. You need to be looking at the contract and the label you've given them actually match the reality of that relationship. So maybe you've called them self-employed, but are they really looking at those various tests that we've just looked at? You also need to keep it under review. So it's very commonly the case that someone may well start out genuinely as a self-employed contractor, but the nature of that relationship evolves over time so that they become a worker or maybe even an employee. So these things need to be kept under review. And particularly in cases where the relationship may be prolonged or for some reason they're considered high risk, it would be wise to set a regular review period. If you don't think it's matching up, so that the contract doesn't match the reality of the relationship, then ultimately you either need to, which we wouldn't advise, just bear that risk and carry on, or more realistically, make sure your contract and you are treating that individual correctly. So you may need to move that individual onto a new contract and manage that relationship in a different way. Now, what we would say there is you need to act very carefully. And there's a number of reasons for that. One, in maybe moving someone from a self-employed contract to a worker or an employee contract, you want to ensure that you're not necessarily accepting that they have been a worker or an employee prior to that period of time. You may be willing to accept that you will give them paid holiday and guarantee a certain minimum level of pay moving forward, but you may not want to accept a historic liability. Secondly, you also need to be careful that in making changes to one person's contract, you don't undermine the status or the relationship that other people have. So it's something to consider quite carefully. And it should also be said, particularly when you're talking about someone moving from self-employed to maybe a worker or an employed status, they may not want to move on to that type of contract or have that type of relationship, particularly if it means that they're going to be more tied into you, or indeed their tax status will change. So it needs to be handled quite carefully. I think it's also wise to ensure that your contractual terms are up to date and have been recently reviewed. Now, the Uber case made it quite clear that how you label somebody and the contract that they work under is not determinative. So if you call someone self-employed and they work under a self-employed contract, that doesn't necessarily mean that they are. However, it is still one of the best ways that a business can protect itself and ensure that relationships are properly managed. So you should make sure those contracts are up to date. So a few final points before we wrap up this section on employment status. Usual caveat applies to this webinar. This obviously is only a very brief introductory summary of some of the principles that have come out of that Uber decision, and indeed how to classify your employees, workers and self-employed. You should take legal advice on your own specific circumstances, and that particularly applies to this area where it is very fact specific and the outcome will change from case to case. The other thing I would add is that we do offer, and quite happily to extend to anyone watching this webinar, a checklist which helps set out in more detail those factors that I've just run through in terms of whether someone is an employee or self-employed. And if you'd like a copy of that, just drop me a line and I'm quite happy to send that out to you to have a look at. The other thing I'd just highlight, if you found this of interest and would like to hear about future webinars or indeed receive the regular employment law updates that we produce, then again, just drop me a line and I can send you some examples of that for you to take a look at, see if it's of interest. And equally, would love to hear your feedback. Any questions, feedback or suggestions, then please just get in touch. And there's my email address and my direct line, so please do just give us a ring. If you haven't already watched them, there obviously are 3 other parts to this webinar dealing with holiday pay, data protection and gender pay reporting. But that concludes this section.